All right. Thank you. And good morning, everybody. And thanks for joining us today in our 56th installment of our EO Exchange series. As we've previously discussed, due to the tragic loss of Matt Carney, a lot of us have been thinking and questioning, do I have my own estate planning and other end-of-life needs completely in order? And because of that, we have prepared a comprehensive four-part series dedicated to making sure we all have our house in order just in case something should happen to us as entrepreneurs, spouses, partners, etc. So in today's part one series, we'll hear from experts at Baker Donelson on the essential legal steps every entrepreneur should take to get your house in order and safeguard your loved ones. They will guide you through the basics of estate planning, including creating a proper will, establishing trusts, power of attorney, and more. So let me introduce our experts. Steve K. Wood focuses his practice in the areas of federal and state income taxation, estate planning and administration, including corporations, partnerships, LLCs, and tax-exempt organizations. Prior to his law career, Steve was a member of a tax practice of a national accounting firm and is a licensed CPA. Examples of his work include structuring grantor retained annuity trust, GRATs, for a local executive and business owner, and legally shifted more than 20 million appreciation to the next generation without estate or gift tax. He's also represented a national trust company in the administration of an estate valued at more than 75 million. He was recently named to the Best Lawyers in America 2025 listing in the areas of nonprofit, charities law, tax law, and trusts and estates. We also have Chuck Goldberg joining us. Chuck represents individual and business clients in the areas of federal and state taxation, estate planning, business succession planning, tax controversy, business transactions, and business law. Previous to Baker, Chuck served as a senior vice president at a large national wealth management firm, servicing and advising that firm's ultra high net worth client base. He is also a licensed CPA. Like Steve, Chuck was also added to the Best Lawyers in America 2025 listing, a list that only names 285 attorneys and has a voting population of more than 184,000 lawyers around the world. Gentlemen, thank you for joining us this morning, and take it away.
Thank you, David, for the introduction. I don't know that I have much to say about my background, or probably Chuck is. You did a good job, but why don't we jump right into it, I guess, and please interrupt us with questions, or and I believe you're going to use chat, and David, you'll be bringing those to our attention. So please interrupt us when needed. We're going to provide an outline sometime during the presentation, but and go through the various details that we think you ought to be thinking about. First document we'll talk about is a general power of attorney, and where that comes into play primarily, and from a both a business owner and personal standpoint, is someone becomes incapacitated. There are statutory requirements that have to be met. For example, the document must say it survives incapacity. If it doesn't include that language and someone became incapacitated, it would expire. So that's very important. But thinking about it from the business owner standpoint is what happens when you, as a business owner, especially if you're the sole business owner, should become incapacitated, whether it's from an accident, a stroke, you name it. All those events can affect a business owner and the business they run. Chuck,
yeah, just to add a little more color to that, really the purpose of a general durable power of attorney is so there's not a gap in your ability, or not your ability, but anyone's ability to transact on any transaction that needs to occur while you're unable to make decisions on your own behalf. And so this document gives another person, that a trusted person, that power. Another thought I want to add to that is this is a legal document, this drafted, but it's between you and your attorney in fact that you're naming. It's a good practical matter, in my opinion, particularly when dealing with financial institutions, to share this power of attorney with them prior to actually needing it. Just so they're aware of it, they can comment on it if they have any questions on what may or may not be covered under that power of attorney. It would give them a chance to speak up, so that in the unfortunate event where it's necessary, where you need to use it, there would be less likelihood of actual pushback on that when that document's presented to them.
Yeah, and I'll just tell you, my experience is Merrill Lynch and Bank of America, you should definitely share them with those institutions. Because I've run into situations with both of those institutions where there was difficulty. The other thing I would add to what Chuck said is that it's not necessary that you have one attorney in fact that covers all affairs, but for example, in a business, you might appoint someone that either has business experience or experience with that particular business, whereas you might appoint a spouse or another significant other or child to serve as attorney in fact on your general financial affairs. Well, we will go to the next important document, which I hope all of you have, and that is a last will and testament. Just to describe what that means in the state of Tennessee. In Tennessee, you can have two forms of wills. One's called a holographic will, which all the material terms must be in the testator, and that's the person who's executing the will, and the testator's handwriting, and it must be signed and dated by the testator. Typically, you do not see those, and I don't encourage anyone to do that, but from time to time, people will be out the door on their way to the airport, and they may do that. The second type is the type that Chuck and I assist people with all the time, and that is, a typewritten last will and testament. In Tennessee, it has to be executed by the testator. They have to declare it's their will. They have to request the witnesses to sign the will, and everybody's got to be in the same, let's just say the same room when it's done. And then typically you will have a self-proving affidavit that the witnesses also sign that eases actually probating the will in the event someone should pass away.
And I feel like most of the general population, entrepreneurs included, have a good general sense of what a will is and what it's trying to accomplish. But ultimately, a few big things are happening. You're naming a party responsible for the administration of your estate. That would be your personal representative, who's going to be in charge of collecting all your assets, paying all of your expenses and debts, upon collection of those assets, and then distributing your assets pursuant to the terms of your will. And what those terms look like are highly personal to every individual. So it's there's no one size fits all approach there.
And just to point out what happens if you don't have a will. And gosh, I executed a will with someone earlier this week who successful business person, kids are grown up and they still didn't have wills. So, but they did come in and sign new wills. but what happens if you don't have a will? Number one is if you're married and have a spouse, you know, it may not be a huge problem because you may have all your assets jointly titled. If you don't have them all jointly titled, then you have to go to court and get an administrator appointed, which serves the same function as the executor that Chuck described. And then the estate gets distributed among the heirs at law, which if you're married, the spouse is entitled to a share. If you don't have children and you have a spouse, everything goes to the spouse. If you have children, then you have to determine child share. So if you have one child, then it's 50-50 between the spouse and that child. If you have two or more children, then the spouse gets 1/3 and the balance gets divided among the kids, regardless of their ages. And you don't have a guardian name for your children, which you would typically do in a will. And one of the problems is if you're the owner of a closely held business, number one is that administrator might not be the person that you would have in mind to deal with that business. And secondly, is there may be some delay. So, you know, the huge concern is you're the sole owner of the business, and what happens payroll, what happens during that period between your passing and you having an administrator appointed by the court. There might be bond required. The administrator would most likely have to post a bond with the court unless it's waived. So what else would you have in mind, Chuck?
And I'll add to that too, whether there's you have a will or not, whether this is an intestate or testate estate, there may be a gap in operations where for your business between period of death and the appointment of the appropriate party to administer your estate, whether it's going to probate court, chancery court, and getting your last will and testament admitted, or and then the executor administrator appointed, letters testamentary being issued, and that gives them the legal authority to act on your estate's behalf. So I think this dovetails nicely into revocable trust. Steve, you want to comment on that?
Sure. So, and you may have heard of what a lot of people refer to as living trust, revocable trust, and what those involve are the creation of a present trust during your lifetime that you have the power to revoke. You name trustees, and then upon your passing, the trust becomes irrevocable. And generally, the revocable trust serves as a substitute for your will, although we believe you also need a will. But the beauty of a revocable trust from a business owner standpoint, again, going back to where you're the majority owner or you're the sole owner especially, is there is not that delay in dealing with the business that comes with waiting for either an administrator or an executor to be appointed. As of the moment of death, the successor trustee, and you would typically name a successor trustee, would step in and would have control of those assets. Sometimes in dealing with financial institutions, and maybe even with, let's just say you've named a spouse or someone else as a trustee, you might name let's just call it a special trustee to deal with the business assets. Number one is because a financial institution typically is not going to want to have the liability associated with managing a business, whereas your business associate is more prepared to do that and probably has much more knowledge about what you would want to do in that situation.
Yeah, and as Steve mentioned, the revocable trust is really, it's often thought of as a will substitute, but it's really just an additional layer on top of a last will and testament, where your last will and testament would pour over all of the assets in your estate into the revocable trust agreement, and then the revocable trust agreement would really capture all of your dispositive intent for your assets after death. Something that gets lost in this conversation a lot is this is a revocable trust, in that it is completely amendable. It can be undone. You typically, the individual creating the revocable trust is the trustee during their life and up until their incapacity. So property that is held by that trust during life and incapacity, you have the ability to transact with that property just as you would as if it were in your own name.
Yeah, and let me add two things. Number one has no bearing on your estate tax liability because it's revocable. It's not a completed gift. You haven't done anything with removing those assets from your estate. And the other thing that's important is because it's revocable, it's treated as what's known as a grantor trust. And there's really no income tax significance to it. All those assets continue to be reported on your personal income tax return.
I have a question or a comment. Doesn't it also seems preposterous to me, but it's my understanding a will is can be public information otherwise. And if you pour it into this pour over will or this trust that you're describing, everything is completely private and hidden.
That's absolutely correct. So to the extent you have assets in an estate that is being probated, those are public record. That would be filed in court. To the extent assets are titled to a revocable trust, they avoid probate.
Right.
Now, and that also brings up the point of what is probate involved. And it would involve assets in your estate being of record to the court. It's also in many cases a factor of difficulty of administration. In a lot of states, Florida, for example, the probate process is extremely burdensome and complicated and expensive. And so in those states, it makes complete sense always, I would say, to have a revocable trust in place. In Tennessee, the probate process is not nearly as burdensome and as maybe not as intrusive, but still, I would say for most business owning clients, a revocable trust can make a lot of sense.
And one other point on that is if you have real estate located in various states, it's possible that you're going to have a probate procedure. And let's say you live in Tennessee, but have property in Florida, you name it, North Carolina, wherever. You'd have a probate in Tennessee, plus you would have to file either wills to prove muniment of title or file for an ancillary administration in these other states. By using a revocable trust and placing the real estate in the revocable trust, that would avoid probate issues in other states. Well, why don't we go into some of the other issues we want to cover?
Before you move on, when you talk about the importance of titling assets to these revocable trusts and how that has an effect on these instruments.
Sure. Yes, titling is very important if you really want the revocable trust to have its impact that you're expecting. And that's because to the extent assets are titled in your individual name, and without a beneficiary designation to the revocable trust, they're going to be part of your estate, whether you have a trust in place or not. So it's important to either title assets to your revocable trust, or particularly for financial accounts, perhaps name the revocable trust, the payable in death beneficiary designee of those assets, such that the property will pass at your death by operation of law to the trust agreement, and the trust will have good legal title without necessity to actually probate and get those assets into the trust.
And as far as getting more specific on titling, and this is somewhat now more of a personal preference since our real estate statutes have changed, but a trust is not a legal entity. So typically if I had, we'll say Charles Frazier, serving as trustee of the ABC Trust on real estate, I would have a deed that would name Charles Frazier, trustee of the ABC real estate trust, dated whatever date. You know, from a real estate standpoint, that's the way we used to do everything. They have changed the statute in the last 2 years to say you can actually make a deed to the ABC real estate trust. But again, since a trust is not a legal, I mean, what a trust really is it's the splitting of legal ownership from beneficial ownership, and truly the trustee is the legal owner of the property.
Would that also apply to the ownership in your business? So I think, everybody kind of has their business structured in a certain type of way. How would you suggest that be pivoted rather than being in their individual name if they were going to deploy a living trust strategy?
I would say absolutely that if you're going to have a living trust strategy, that the ownership of your business should be titled to that trust.
Well, why don't we move on and cover a few other topics since we have limited time. Life insurance is the next thing that we had on our list to discuss, and everybody's probably got a association with a life insurance agent somewhere. But there are lots of different needs and uses for life insurance. One is for your business to provide for the loss of a key person to that business and keep the business up and running so that it can continue to thrive and maybe pass on to the other business owners.
And I think a good baseline question when thinking about life insurance is what purpose is this policy intending to serve? And oftentimes it is liquidity to help transition business ownership to one of your partners, perhaps, or there's some other form of redemption or otherwise. But then also from a general matter, it's often for your family to replace lost income, or in higher value estates for where estate tax is going to be due, to provide liquidity so that perhaps the intent's not to sell the business at your death, and there's going to need to be liquid assets available to pay estate taxes after death.
Yeah, and one other use to be considered is if you have multiple owners of a business, is potential use of life insurance to buy out another owner of the business. So that's something to think about, and we'll discuss those business agreements in a few minutes, but that's commonly used as a technique to provide for the buyout of a deceased member of the business. As far as additional insurance, disability insurance is something to think about. I remember when I was just out of law school, and I bought disability insurance, and I think the agent very adeptly pointed out that was more likely that I would become disabled than die before reaching the age of 65. And so it replaces income, similar to life insurance, but it can also be used as a source of funds to buy out a disabled partner in the business.
Yeah, I have nothing to add to that.
Yeah.
Good point.
All right, so we've gone through those nitty gritty of the bad things that can happen to a business owner. And one of the things that if you have multiple business owners, which should be considered in all instances, is okay, what happens if one of us quits? If one of us becomes incapacitated, if one of us dies, what's going to happen? Do I want my partner's executor or whoever stepping into a co-ownership role, or do I want to have some means in some way of setting a purchase price so I can fairly treat my former partner's estate or heirs, or to buy that person out. And typically that will come through, if it's an LLC, you'll have provisions in your operating agreement. If it's corporation, you would probably have a shareholders agreement to do that.
Alternatively, a way I like to look at it, Steve just framed it from the departing business owner's perspective. From if you're a business partner and your partner deceases or exits the business in some way, do you want to be partners with their? I think the answer is no. You do not want to be partners with their estate, with their family members. So these are just things to think about before that issue ever arises. Is how will we treat one of the partners leaving the business?
And how will we determine the purchase price if we're buying that partner out? So,
Yes.
well, the last thing we want to cover, and this, I see it more and more. In fact, Chuck and I are working on a few of these right now, but prenuptial agreements for, the single business owner who, is getting ready to step into a marriage. And although we always look at these with hope that the marriage will last forever, number one is we know all of us, at some point are going to depart this life. And then secondly, sometimes the marriage, unfortunately, will be dissolved prior to that time. And how could that, number one is there are other assets, how can that affect those other assets? And number two is, how are we going to treat this business in those events?
Yeah, there's you have a business owning single individual who enters a marriage with owning an interest in that business, and they're married for 10 years, and the business grows in value substantially over those 10 years. And they're often shocked to find out, without a prenuptial agreement in place, that even though they own that business prior to marriage, the increase in the increase in value in the business over that period is all a marital asset that's subject to equitable division in the divorce proceeding. So that can be an expensive issue to arise.
Yeah, and another example is where you have a business owner has a son from a previous marriage who is involved in the business, and who the business owner would like to leave that business to, but wants to adequately provide for the spouse, and doesn't have a prenuptial agreement. And if that business is, the most significant asset in that individual's state, under Tennessee law, a spouse has the right, regardless of what the will says, to file for an elective share of the estate, which in Tennessee, it varies from 10% to 40% based on the length of the marriage. So if the individual had left the business to his son and, to give an extreme example, everything else to the spouse, and that business accounted for, let's say, 80% of the value of the estate, even though that remaining 20% was of significant value, that spouse would have the right to file for an elective share and get 40% of the net estate. And so those are two scenarios where a prenuptial agreement would be important in moving into a new marriage.
Nothing else.
A prenuptial agreement is not necessarily a romantic conversation to have. How useful, if at all, could Tennessee's domestic asset protection trust might they be useful in these kinds of situations for protecting assets in these sorts of situations?
And that's a very good question. And I would have a little bit of concern about that. And I haven't seen anything in the courts that would tell me. I know child support, you do not get any child support protection with the domestic asset protection trust. I would say that's a good question that would just need to be looked at in more depth. And it's correct. It's not a romantic topic. On first marriages, especially, it's a difficult topic. I think with second marriages, it's more accepted. It's easier to explain, especially if there are children.
Yes, and often if it's caged, if there's multiple business owners, at least I find it easier to approach the subject, because there's third parties that might need this sort of protection in place outside of the marriage, and kind of someone else to point your fingers at. But it is a very difficult conversation. There's just no way around that.
So everyone feel free to put questions in the chat. Also, I think it's working fine for people just fire away with your questions. Richard had a question about how often are the same people named on multiple documents, executor, on the POA, etc.
Let me put a little color to that. So what I'm trying to figure out is, like, my brother's on this call. He's so much smarter than everybody else I know. So he is on everything. Is that so? Which is bad news for him, right? But at the same time, you don't want to put that kind of pressure on one. And so, like, where is it smart for the same person to do the same things, and where is it the same person do the same things, is kind of really the question. Does that make sense?
No, it does. And I think a lot of the roles had very similar purposes. The general power of attorney and the executor. Well, general power of attorney is kind of like serving as executor during someone's lifetime if they become incapacitated. So I frequently have people have the same person serving in those roles. And I would probably say the trustee, unless you're splitting up duties where you have a special trustee to manage the business, and you have we'll call it the ordinary trustee to handle everything else. I'm not sure that the duties are that much different.
And we didn't address a healthcare power of attorney, so this would be healthcare decisions as opposed to financial decisions. It is pretty common, or would be uncommon, I should say, to see an individual named as attorney in fact under that document where there's no true personal relationship, where it's just a business partner, just because these are healthcare decisions. So that would be one document that might be a bit of an outlier.
And that's basically how mine's divided. So but I'm just trying to make sure I'm being fair to that person too, right? Because it's probably a lot of work. But and this deep, and so thank you guys for doing this. But I think my takeaway, if anything, is get with someone to talk this stuff through, because it's so hard probably to cover these things in an hour. It's so deep.
So I've got a power of attorney, but I'd never heard that I should be sharing that with financial institutions. So you're suggesting like my personal banker and my business banker, they should have my power of attorney in a file that they can access if needed?
Yes, and it's really a matter of sending it over and to them and say, will you get your legal team to look at this, make sure they're okay with it? Because if they're not, we need to make some changes to it so that if we ever need it, there's not going to be a hiccup in, well, is this a valid, has this been revoked? Well, just all the questions that can come up from the institutional side of why they may not feel comfortable relying on a document that some person that they may have no relation with comes up and shows to them, just out of the blue.
The other reason, and I think I always try to avoid this, is number one is you have some people who want to name co-attorneys in fact. Number one is if you do that, you should be very specific that each of them has the authority to act alone. Typically, I think we would want that. Otherwise, your financial institution may require their assent on just about everything. But I think the better thing to do is to name just one person to serve in that role. And if you want a successor to that person, then name a successor.
So Bert Lyles is asking, does a grantor trust offer protection from tort liabilities?
It does not. It does not offer any does a grantor trust? That's a different question than does a revocable trust. So let me back up. A grantor trust can provide the beneficiaries of that trust protection from tort liabilities. But a revocable trust, which we discussed earlier, would not provide any protection.
Yeah, and when I think about grantor trust, I'm thinking from an income tax standpoint. So if you have an irrevocable trust that is a grantor trust for income tax purposes, that can provide protection. And then I would just add on, if that irrevocable trust provides any income to the grantor, then you have to satisfy the Tennessee statute requirements for what's known as a Tennessee Investment Services Trust. And in that case, you can also provide liability protection to the grantor, but you have to toe the line on qualifying it as a Tennessee Investment Services Trust.
And as Steve mentioned earlier, that protects against most creditors. An effective Tennessee Investment Services Trust protects against most creditors, but not all creditors.
Samir asks, how often do you split the power of attorney among all children for an aging parent?
Did you say split the power of attorney?
Or I guess name multiple individuals as having power of attorney?
We're talking about multiple individuals serving all at the same time?
Yes, I'm assuming that. Yeah, I think I have my children all as having power of attorney.
I would say infrequently, and then when I do, I just caution them if it's joint, then they should expect to all have to sign documents, and if it's either or, then I would just be very clear on the document that each of them can act alone.
Yeah, and from the person creating the power of attorney, often they see it as, well, it's unfair to, I have 3 children, and it's unfair to my 3 children to name one of them is attorney in fact, and the other 2 are down the line in succession. But it's just impractical to have all 3 there. And usually when you explain that, just the practicality of the situation, it makes sense to, well, there does need to be a pecking order, because if we need this, we don't want to run around getting 3 signatures for everything.
As a personal experience share, as my parents got older, they had originally 2 of my sibs as healthcare power of attorney, and 2 as financial power of attorney, each empowered to act individually. As Mom got older and Dad passed away, we were all happy to have individual power of attorney, because none of the children lived in the same city as my mother, and whoever was there needed to be empowered to help Mom without jumping through the hoops to track down distant siblings. And as long as the family is strong, my limited experience with that is that it was very effective for us.
Well, I think those are good points, Bert.
So Allison Reynolds asks, if you have a large amount of appreciable assets and wanted to get a step up in basis at the first spouse's date of death, would a community property trust be beneficial, or is the exposure to the asset too great?
It would be, and the first answer is, to the extent it's owned by the community property trust under current law, you get a 100% step up in basis at the time of either spouse's death. As far as the exposure, I don't know that it's any more exposure, with one exception, than, owning the property individually. I guess, yeah, if one spouse has liabilities, 50% of the assets that are in there are exposed, but the other 50% are not. If it's jointly titled, real estate is generally protected because it's owned as tenants by the entirety, but all your financial accounts that are jointly titled are exposed to either spouse's liability. So I don't see the liability issue as, I personally, I wouldn't consider it that great. I think the basis step up is a significant benefit.
I guess I was just wondering, why would someone choose a community property over a revocable living trust? And I thought that it was, my limited knowledge, that it would be a revocable living trust would offer more protection to the assets versus a community property trust. But a community property trust sounds pretty attractive from a tax step up standpoint.
Yeah, and I would argue that a community property trust provides more protection than a revocable living trust, because once you place the property in there, 1/2 of it is one spouse's property, 1/2 of it is the other spouse's property. So that 50% to one spouse is protected from everything that the other spouse does.
Yeah, with the caveat that by placing property in a community property trust, it does become community property.
Yeah.
Yeah, so if you had a couple that was secure in their marriage late in life, maybe, and you didn't have the concerns of some of the, things you addressed with a prenup, that might be a good vehicle if you had appreciable property.
Absolutely.
Yeah.
From a legal standpoint, if the, in the worst case happens, as we had happen, what are all the things that you should have in place to make sure that your people can get paid on time and it doesn't cause financial stress for your employees?
Well, and, I know a little bit about what you're talking about, but I don't know all the facts, but let's just say you have a sole business owner, they own, you know, the business through an LLC and don't have a member, another member or partner. You know, the best thing I think you could do would be to set up a revocable living trust, have the living trust own the LLC, and you know, through both the living trust and the LLC documents, be clear on who becomes the manager of the LLC, have, you know, a successor trustee of the revocable trust, and then, you know, owner passes away or becomes incapacitated, the successor trustee steps in immediately as the business owner and can continue paying employees, can run the business, can dispose of the business, do whatever is necessary without it. It's going to be a crisis, but it's not going to be as large a crisis as maybe would otherwise have been.
I had a comment that I think that I have not done this yet, but I'm planning to, just from the tragedy of Matt, and it made me think about it. All these wills and trusts are obviously critical. Everyone should have it already, frankly, but if they don't, get with a professional to help figure it out. But what I intend to do is, in essence, put together where it's known in a fireproof safe. I'd call it a playbook. If I die, here's the list of all the insurance policies, which are not all in one place, all of the banks, all of my key advisors, and maybe a narrative also of which executives do I trust, who can you go to for this advice, for that advice, which lawyer, you know, like certain spouses know more about one's life and business than others. And if they're not in the know, they're not going to have a clue of where to go, where to act, or who to trust, or what some guideposts are. You know, your will's there and major assets are listed and gifted or whatever, but just the game plan on who to go to, who to call, what to do, what your wishes are in really specific ways. I think, well, in my case, would be very, very helpful to my survivors, and I've not done it. And that's an action plan that I'm intending to go from here. And then others go ahead and write their obituaries or have their, you know, what they want for their funerals. If that hasn't been discussed, which it hasn't in my case, that's such a burden for someone to figure out at that time as well. What do they want, et cetera. And if a lot of those decisions and directions are given, I think it takes a lot off of the survivors. And again, I'm guilty of not doing it, but that's what I'm doing this fall.
That is an excellent promotion for next month's EO Exchange, because
Good.
we cover all of that information.
Oh, beautiful.
About putting that playbook together.
Yeah.
Yeah, I hope that this 4-part series, that at the end we have a checklist, that a very comprehensive checklist of all those things. And I'm with you, Vince. I have not. There's a lot of things I haven't done that hopefully this is going to spur me to get done.
And I'll chime in. There's actually companies out there that provide services where they help clients aggregate all of their assets. They give you a platform and you just put all of your stuff in it slowly but surely over time. And then maybe have an envelope in your nightstand where you provide the key to the, you know, place where all of the treasure trove is, and then all your stuff is there. And so you don't really have to think about where to put and how to come up with this big playbook. People have already done this stuff. And so those are things. So you don't have to recreate the will. You know, people have already done this for you. And there's I know a lady here in Murfreesboro who actually provides that service for families as well.
So any more questions? Let's see if we got any more questions. Fire away. If not, I think we're going to go into breakouts. We got about 10 more minutes.
Yep, I will open those rooms, and Danielle just put the questions in the chat. So if y'all want to kind of take a look at that while you can see them, and I will go ahead and open the rooms, and then we'll come right back in 10 minutes, or maybe like 8 or 9 minutes.
Mhm.